Good afternoon, everyone. Welcome back to my channel, True Crime Files with Kathy. Housekeeping rules. If you can click like and subscribe, please. And if you subscribe, click all, and then you're notified every time I upload a video or short, or if I do a live. Right, today's story is the Boston killer, Lindsay Clancy. She's got sort of like quite a lot going on with her, mentally health issues. She allegedly killed her 3 children, but her husband doesn't really blame her, which is understandable because he's been there when she's been um, through the mental health things, and she was institutionalized because of it. So I'll just read a few things out first, and then I've got some videos and things to play to you. So just bear with me a minute. The grieving husband of a nurse who killed their 3 children has revealed in a haunting phone call that day and the chilling reason she strangled them. I must have to warn you all, this does come with discretion warnings, graphic warnings as well. So if you're likely to be affected by this story, then perhaps this isn't the story for you to listen to. Patrick Clancy returned home to find Lindsay with slashes on her neck and wrists, and Cora, 5, Dawson, 3, and Callan, 8 months, strangled in their basement. Cora and Dawson were dead. Kaylin died a few days later. His wife had brutally killed them before throwing herself from the window of their mansion in Duxbury, Massachusetts, back in January 2023. In a heartbreaking interview with the New Yorker, Patrick speaks out about that day and opens up how he and Lindsay, who's now paralyzed, have interacted since. One chilling extract describes him calling her from a CVS store. When she rang back, she was normal, but she seemed to be in the middle of something. So you can see them there with their children. They look like a normal, happy couple, don't they? Yet he says he does not blame Lindsay for the killing of their 3 children. I wasn't married to a monster. I was married to someone who just got sick, he said. He told how she had been suffering from anxiety and was institutionalized in the months before the horrific accident. He said just a few days before her arraignment, a voicemail was left from a phone number he didn't recognize. It was Lindsay calling from a psychiatrist's phone to say she loved him. When he called back the next day, Lindsay explained that she had heard a voice commanding her to kill the children and then kill herself because it was her last chance. She did not sound like my wife, Clancy said on the phone call. So there's the 3 beautiful children. I'll just check that you can still see it as I'm scrolling. That's their house. There is also some more photographs to show you, but I'll just read this next sentence and then I'll go through the gallery with you. It was 6 months before the couple spoke again, and Lindsay told her husband how every day was the worst day of her life. She misses her kids, Clancy said, which I know sounds crazy to some people, but that is the reality. Lindsay's friends also have previously told how she joked about them having enough children to fill a baseball team. She said she was born to be a mother, but Lindsay apparently started to struggle with anxiety shortly after the birth of her younger son, Callan, who was just 8 months old when he was killed. She told Patrick she wanted to go onto Zoloft as she prepared to return to work and started seeing a virtual therapist. Those virtual visits, though, were more centered on medication management, Patrick said. So, sometimes when women have children, they do suffer from postnatal depression, and it can be a nasty thing if it's not caught early and treated. And some people are lucky enough to have a really supportive network around themselves where they can get the support and all the help they need. And some people just stand there and suffer in silence because they don't know how to reach out. So this was their semi-house they had. It's a picture of them on the phone. Revealed the horrifying phone call he had with his wife on the day of the 24th January 23 when she said she'd strangled their 3 children. That's 2 of the children there looking all happy. And father with a little one in a pool. And another one. So you can see how happy she looked. You know, she doesn't look like some of these monsters. Now I'm just going to play this one for you. It's from 2023, the police radio, after Mum Lindsay Clancy strangled herself. I've turned my settings up as loud as I possibly can. So if you're struggling to hear this, you might need to just adjust the volume on your side of things. Just enlarge this and check what it looks like on StreamYard. Right.
Dispatching about a call, respond with the police. 4747 Summer Street, female party jumped off the top floor of the house and suicide attempt 12-18-12. Quick fire dispatch handed 2 car 38147 Summer Street, respond with the police. Female party jumped off the top floor of the house, slice her wrist as well, and neck injury, neck laceration. She's conscious at this time. We're going to check with MedFlight. It was over a 20-foot fall, 18-14.
So as you can hear there, she jumped from 20 feet and she has neck injuries, which leads her to being paralyzed.
It's unknown where the knife is or whatever she used to slit her. She's in the, looks like they're pinging her on the back. We'll get that info now.
I'm going to get all 3 mutual aids at this time. I'm getting you 3 mutual aid ambulance cab. I struck the box. We got 3 on the way. Okay, I got 1 here. I got 4 patients total. 7 Summer Street. 30 ambulance in for a suicidal situation. Time of 1821.
So that's the end of that recording. Don't know what this one is. Kurt walked after being judged. I think this is still the same thing. Couldn't be, because I thought she was paralyzed. Don't think that is Lindsay, is it? Can't see. No, I think that must have been... No, they're just doing other things. So let me come out of the video side of things. So there's the other photo of them together. There's some more photos there as well. So Patrick Clancy revealed the horrifying phone call he had with his wife, Lindsay, the day of January 24th, 2023, as she strangled their 3 children. So we'll just see what photographs are going through here. Oh, we've seen these. That's the police, yeah. So we've seen that one. So by mid-November 2022, Lindsay had lost her appetite and stopped socializing. She also started having trouble sleeping, prompting doctors to prescribe her even more medication. Lindsay's defense attorneys have argued horrific over-medication was the cause of her mental decline. Even prosecutors revealing in court that her blood samples found there were 7 different types of medications. Investigators found bottles of diazepam, amitriptyline, trazodone, and all antidepressants from the family home. All 3 had been prescribed to Lindsay 16 days before the tragic incident. By the end of that December, Lindsay insisted she needed to go to hospital, telling Patrick, "I have thoughts of wanting to die. I feel numb to them." About the same time, Lindsay also confessed having unwanted thoughts about harming her children, Patrick later told the police. Then in early January, Lindsay checked herself into the McLean Hospital, a psychiatric facility. But when Patrick visited her later in the week, they saw clearly how agitated an individual pacing the hallways and talking to themselves, he said. There were people who were clearly like nuts, he said. Lindsay seemed to have it together, he added, and she had texted him saying, "I don't belong here." She was released from the hospital just after 5 days with a prescription for an antidepressant and denied having any more intrusive thoughts. Patrick had thought she had been improving, and on the morning of January 24th, she even told him she was feeling good and slept pretty well. She became concerned about her daughter's stomachache later in the day and took the young girl to see a paediatrician. Lindsay texted Patrick around 5 p.m. to pick up Pedialax for Cora and take out meal for dinner. He did not think much of the request at the time because he thought she was doing better, he revealed. But he said, "If I could go back in time, I would have called McLean and said, take her away, lock the door, keep her in there for a year if you have to." He noticed she seemed really good that day. So what do? Somebody's having a great day. Should I call the hotline? So that's the thing with sort of like antidepressants and things. You can feel good one day and then terrible the next day. Or even, you could wake up in the morning in a fantastic mood, but by lunchtime, your mood has changed considerably for the worse. I don't know if we've listened to this one.
Sorry, dispatching a medical call. Respond with the police. 4747 Summer Street. Female party jumped off the top floor of the house in the suicide attempt. 1812. Quick fire dispatch hand in 2 car 3A147 Summer Street.
Yeah, we have, but listen to it again.
Female party jumped off the top floor of the house. She did slice her wrist as well. And neck injury, neck laceration. She's conscious at this time. We're going to check with MedFlight. It was over a 20-foot fall. 1814.
It's unknown where the knife is or whatever she used to slit her. She's in the. Looks like they're pinging around the back. We'll get that info now.
I'm going to get all 3 mutual aids at this time. I'm getting you 3 mutual aid ambulance cabs. I struck the box. We got 3 on the way. Okay, I got 1 here. I got 4 patients total. 7 Summer Street. 30 ambulance in for a suicidal situation. Time of 1821.
Yeah, oops, we don't want to play that game. When he returned home, however, he found blood on the floor of the master bedroom and a bloody knife. He found Lindsay barely conscious in the backyard and asked her, "What did you do?" To which she replied, "I tried to kill myself." Patrick then asked where the children were, to which she replied, "In the basement." That is where he found Cora, Dawson and Callan with exercise bands still around their necks. He tried to remove them and begged each child to breathe before they were pronounced unalive. In the aftermath, Patrick said he questioned his wife about what had happened that day. "I think one of the first things I asked was, 'Did you plan this? Is this why you sent me out?'" he recounted. She said, "No, it was just like a snap of the fingers." He said he asked why she looked up how long it would take for him to pick up dinner, to which she replied she was concerned about him getting stuck in the traffic. Then I said, did you Google ways to kill? And she said, yeah, for myself, because I was suicidal for 2 months. See if there's any more different pictures in this one. So Lindsay pleaded not guilty to 2 counts of murder, 3 counts of strangulation, and 3 counts of assault and batter with dangerous weapon. Yeah, so these are just going back to the same old photos. But yeah, to look at her, you wouldn't think she had any mental illnesses. Lindsay has pleaded not guilty on 2 counts of murder, 3 counts of strangulation, and 3 counts of assault and battery with a dangerous weapon. Defense attorney Kevin Reddington, who has indicated that he plans an insanity defense, painted a picture of a woman who was struggling with mental illness. This is not a situation that was planned by any means, he said. This was a situation that was clearly the product of a mental illness. But the prosecution countered that Clancy had been evaluated by the medical health professionals before and was told she did not have postpartum depression. They claimed Lindsay had been researching ways to kill on her cell phone in the days leading up to the murders and have suggested a suicide attempt was staged. A date for a trial has not been set yet. So I think that's all on that one. So if I go back to here, remove this one, and then see which video comes first. 2 years, 3 years, 2 months ago. So if I do 3 years ago, I'm going to just make sure you can see it, which you can't. Right, need to remove that one. Stop screen. Right, start again. Share screen. So just check which one it was. Was it that one? Yeah, so I can get rid of that one and go back to this one. So it's the YouTube one. Check the sounds all the way up. This goes on for just over 14.5 minutes, where she's obviously in hospital, and we'll see what she has to say.
Based on the facts of the case, the strength of the Commonwealth's case, and the potential penalty.
Oh, there we go.
On Friday, January 27th, 2023, using an erasable whiteboard because she was still temporarily intubated, one of the first questions that Lindsay Clancy asked was, do I need an attorney? She knew that she had murdered her children, and she had the clarity, focus, and mental acumen to focus on protecting her own rights and interests. The following is a summary of the events that led to the murders of Cora Clancy, Dawson Clancy, and Callan Clancy. On the morning of Tuesday, January 24th, 2023, the defendant took her 5-year-old daughter, Cora, to the pediatrician's for an appointment. She interacted with a receptionist, nursing staff, and a doctor. There were apparently no issues with the defendant's demeanor or behavior as she completed the appointment and was allowed to leave with Cora without any issues or concerns. When she returned home, she went outside with Cora and a 3-year-old son, Dawson, to play in the snow. They built a snowman. The defendant sent photos to her mother and to the defendant, to her husband. She texted with them. Nothing in the text was out of the ordinary or any sign of any distress or trouble. Back inside later that day at 4:02 p.m., the defendant searched on her phone, Kids Miralax. She then searched at Takeout 3V via her cell phone at 4:13 p.m. Immediately after doing that, she used Apple Maps on her phone to determine how long it would take someone to drive from her home in Duxbury to 3V restaurant in Plymouth. So she would know how long someone would be gone if they ran that errand. She next went on the CVS website at 4:47 p.m. and then called CVS on Summer Street in Kingston. She spoke to the manager of CVS and asked if they had the Kids Miralax. The manager told her no, but they had other similar medications. According to the manager of CVS, her voice did not sound slurred or impaired in any way. She had no trouble understanding the defendant, and it was a perfectly normal conversation. At 4:53 p.m., the defendant texted her husband, who was working in his home office in their basement. She texted, "Any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day." This was an unusual request, as when the family ordered takeout, they'd usually go somewhere closer to home, but it was a place that they had been in the past. Patrick Clancy texted back yes, and then the defendant asked him to check the menu. At 5:06 p.m., the husband texted the defendant asking what she was going to get. She responded, "A Mediterranean power bowl." She spelled it correctly, and it was something that was on the menu. He then told her that he wanted the scallop and pork belly risotto. At 5:10 p.m., the defendant called 3V Restaurant to place the order. She got the order correct. She gave the correct name for pickup, Patrick. The hostess who took the call said there was nothing out of the ordinary about this call. She was able to understand the defendant, that her voice was not slurred or impaired in any way. At 5:15 p.m., Patrick Clancy headed out the door to run these errands at the defendant's request. As he left, she texted him Pedialyte liquid stool softener. Surveillance footage shows Mr. Clancy at CVS on Summer Street in Kingston at 5:32 p.m. He goes to the medication aisle, the children's medication aisle. Phone records show that he called the defendant at 5:33 p.m. and she did not answer the phone. He then calls him back at 5:34 p.m. and the call lasted 14 seconds. He's there at the store unsure of which medication to get, and she tells him exactly what she wants. He had no issues communicating with her. It was a completely normal call, although he did mention that she seemed like she was in the middle of something. He is on surveillance footage during this time, exiting that aisle and appeared to be using his phone. He then heads to the register, makes his purchase, and leaves the store at 5:37 p.m. He's next seen on footage at 3V Restaurant at 5:54 p.m. He picks up the food and he's out of there within a minute. When he arrives home, the first thing he noticed was the silence. He did not see or hear the defendant or the children. He actually called her cell phone at 6:09 p.m. looking for them, and she did not answer. He went to their bedroom on the second floor and the door was locked. He was able to open it, and when he looked inside, he saw blood on the floor in front of a full-length mirror and the window open. He immediately runs downstairs and into the backyard, where he finds the defendant laying on the ground. She appeared to have cuts on her wrists and neck, but he stated to 911 that those wounds were no longer bleeding. She was conscious. He called 911. During this time, he asked the defendant, "What did you do?" She responded to him, "I tried to kill myself and jumped out the window." During the 911 call, Patrick can be heard asking the defendant, "Where are the kids?" He later told police that she replied, "In the basement." So immediately after this happened, she knew what she had done and she knew where the kids were. When EMS arrived, he asked them to stay with her so he could go find his kids. The 911 call kept going. Patrick can be heard on the 911 call entering the home and heading to the basement. At one point, he calls out, "Guys." He can then be heard screaming in agony and shock as he found his children. His screams seem to get louder and more agonized as the time passes. Cora and Callan were on the floor in the den area of the finished basement, which is to the left when you walk down the stairs, while Dawson was alone on the floor in his father's home office, which is to the right when you go down the stairs. Each child still had the exercise band that was used to strangle them tied around their necks when their father found them. Dawson and Callan were face down on the floor. Cora was on her side with her torso turned towards the floor. He removed the bands and begged them to breathe. He continued to scream uncontrollably and screamed for officers to come to the basement. The dispatchers are hearing this and they send help down to the basement. And when they encounter Patrick, he yells out, "She killed the kids." The police rushed the children to ambulances that brought them to the hospital. And unfortunately, Cora and Dawson were declared dead at the hospital. Callan was med-flighted to Boston Children's Hospital. Medical staff was able to restart his pulse, but not his brain activity. He was placed on life support for several days before passing away. The defendant was transported to South Shore Hospital and then to a Boston area hospital where she remains. She sustained several broken bones in her back and her rib cage. The police were able to find several notebooks in the defendant's home pursuant to a search warrant, and also notes on her phone that were similar to journal entries. In the months, weeks, and days preceding January 24th, 2023, the defendant meticulously detailed her daily activities, her children's lives, her mental state, and her medication use. Her writing was clear, precise, and articulate. She never indicated that she was hallucinating, delusional, or had disordered thoughts or speech. In all of her writing, she appears to know who she is, where she is, the date, and with whom she's interacted. She wrote a note on her phone the day before killing the children, stating that she had, quote, a touch of postpartum anxiety, end quote, around returning to work. She wrote that her psychiatrist had prescribed medication to help her. The defendant was initially diagnosed, according to her husband, with generalized anxiety disorder. He was then evaluated at the Women and Infant Center for Women's Behavioral Health in Providence, Rhode Island on December 20th, 2022. There, after an evaluation, she was told in the presence of her husband that, by psychiatrists, that she did not have postpartum depression and that she had no symptoms of postpartum depression. She wrote in her journal that at times she had suicidal ideation in December of 2022, and she also told her husband that she had suicidal thoughts and on one occasion had thoughts of harming her children. But she did not write or voice those thoughts after a stay at McLean Hospital. When she had those thoughts, she consulted with a psychiatrist and with her husband, and then she committed herself to McLean Hospital on January 1st, 2023. She was discharged by the hospital on January 5th, 2023. And the hospital did not file any paperwork at that time attempting to have her committed as a danger to herself or others. She also kept meticulous and detailed daily medication logs in a diary that she wrote. She detailed that she had difficulties with each of the medications that were prescribed to her. And when she had issues with those medications, she detailed how her doctor had her stop that medication or wean off of it and then try something else. They were trying different medications to see what would work for her, what would benefit her. According to her husband, she was never on more than 4 to 5 medications at one time. And at the time of the murder, she was taking only 3 medications. And he said to the police that she always took the medications as prescribed. After her stay at McLean, the defendant appeared to be getting better, according to her husband. She slept well, interacted with friends and family. She went out with her kids and husband to places like the Kingsbury Club in Duxbury, the Charlie Horse Restaurant, the Museum of Science in Boston, the Cape Codder down the Cape, interacting with her family and the public without any apparent difficulties. She even stayed alone with the children on several occasions without any issues in January of 2023. Her husband asked her in mid-January, "Are you still having suicidal thoughts?" And she said no. The defendant's parents visited the family the weekend of January 21st, 2023. They interacted with the defendant in person. The defendant was able to run errands while her mom watched the children. She texted back and forth with her mother, and there was nothing out of the ordinary about these text messages. In fact, the defendant texted her mother on January 22nd, 2023 to ask how her ride home went. During this conversation, the defendant's mother wrote, quote, "Enjoyed seeing everyone this weekend. Nice to see you doing better," end quote. On the night of the killings, Patrick Clancy was interviewed by the police at Beth Israel Deaconess Plymouth Hospital. He told the police that the defendant was having one of her best days. She was smiling and happy, and there was no indication that she was going to harm the kids. No one at all described her as acting like a zombie in the days leading up to the murder or on the day of the murders themselves. On February 5th, 2023, this past Sunday at 1:35 p.m., while sitting with Dr. Paul Zeisel, the psychologist hired by defense counsel to evaluate her mental state, the defendant used Dr. Zeisel's cell phone to call her husband. She left a voicemail stating that she loved him. Yesterday, on February 6, 2023, at 10:09 a.m., she again used Dr. Zeisel's cell phone to call her husband. This time he answered, and during this call, the defendant stated that after he left the house that night, she killed the kids because she heard a voice and had, quote, a moment of psychosis, end quote. He asked her what voices she heard, and she said she heard a man's voice telling her to kill the kids and kill herself because it was her last chance. Patrick Clancy told the police the defendant had never heard voices before. He also told the police the defendant had never used the word psychosis to him before. The first time she used that word psychosis was when she was with a doctor hired by defense counsel and using his cell phone. The defendant actually wrote a note on her phone on October 25th, approximately 3 months before this happened, October 25th, 2022. She wrote, quote, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all of my kids." She then wrote that she wants to have more kids eventually. The children were killed by ligature strangulation. Ligature strangulation causes the victim to become unconscious anywhere from 10 seconds up to a minute. The more the victim struggles, the longer it takes. After the victim is unconscious, the ligature must be held in place with force, squeezing the neck for up to an additional 4 to 5 minutes to cause death. Therefore, she had to strangle each of them to unconsciousness and then make sure the bands were squeezing their little necks for several minutes. She could have changed her mind at any point during that time and removed those bands from their necks, and she did not. The defendant did not take advantage of the situation when her husband left the home that night. She created the situation, and she used Apple Maps to make sure she would have enough time to strangle each child before her husband returned from where she had sent him. The defendant is a danger to herself and others. She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom. She did so with deliberate premeditation and extreme atrocity and cruelty. And to supplement what the defense counsel has provided, I have a statement of bail argument to file with the court. Thank you, Your Honor.
Thank you very much.
So that was like one of the defense for talking on her. I just want to share this one. Stop screen for a minute. Share screen. So I looked up postpartum depressive symptoms range from mild baby blues to severe postpartum depression with symptoms varying in intensity and duration. So, like I said, you could be fine in the morning. You could wake up feeling fantastic, and by the end of the day, you're a different person. So, baby blues is 1 to 3 days after delivery, duration up to 2 weeks, and common symptoms are mood swings, tearfulness, mild anxiety, irritability, trouble sleeping. Severe ones, mild self-limiting, resolves with rest and support, affects up to 80% of new mothers. So that's quite a high percentage of new mums that go through the baby blues that can last up to 2 weeks. Mild postpartum depression within the first 4 weeks, duration 2 weeks. And then common symptoms is persistent sadness, mild anxiety, difficulty bonding with the baby, mild sleep or appetite changes. Severity ones, symptoms interfere slightly with daily tasks, like not being able to change the children, not being able to do housework, those sort of things. Slightly different with daily tasks, professional support recommended if persistent. So, you know, they do say to recommend this. Sorry, I got a little gnat or something flying around. Moderate postpartum depression, weeks to months postpartum. Variable. So intense mood swings, feeling of guilt or worthlessness, withdrawal from family, friends, trouble focusing and disrupted sleep. Severe case of it, interferes with daily functioning. That's like looking after the children, doing the shopping, getting herself dressed, doing housework, those sort of things. And then it says therapy and or medication may be needed. So, you know, there's two of the things after the 2 weeks to several months that someone would need some help of some form. Severe postpartum depression and postpartum thing. So usually within the first 2 to 3 months postpartum, variable, so it can stay, duration is variable. Thoughts of self-harm or harming the baby, severe anxiety or panic attacks, hallucinations, delusions, inability to care for oneself or the baby. Then the severity, it says medical emergency immediately, professional intervention is required. So then it just goes on to key points: baby blues versus postpartum. Baby blues are common, mild and short-lived, while postpartum depression is more severe, persistent, and can affect bonding with the baby. Not all individuals experience every symptom, and others may only have a little bit. It's just like any medication, you know, when they give you side effects of certain tablets. Some people may have some of the symptoms and some may never have symptoms. So treatment, like when to seek help: if symptoms persist beyond 2 weeks, intensify or include thoughts of self-harm or harming the baby, professional help is essential. Treatment includes psychotherapy, cognitive behavioral therapy, antidepressants, and in severe cases, medications specially approved for postpartum depression, such as brexanolone and zurolone. This chart can serve as a quick reference for recognizing postpartum mood changes, understanding the severity, and identifying when to seek professional help. So I thought I'd just throw that one in there. Let's remove this one from the stage. Which one was this one? That was the first one. 4 months, 4 months, 54.32. That's 2 years ago. So let's go. We did that one, I think. So we go to this one. Different. Let me share it to StreamYard. Let's get rid of that one.
Lindsay Clancy on indictment 2383 CR 00198. Counsel, for the record, could you please state your name and purpose of the record?
Demonstrate to the Commonwealth. Amanda Powell for the Commonwealth.
Kevin Bennington for Ms. Clancy, who's before the court.
Thank you. Lindsay Clancy, the grand jury having returned on indictment 2383 CR 00198 on offense 001. The jurors for the Commonwealth of Massachusetts on their oath present that Lindsay Clancy of Duxbury in the County of Plymouth, on or about January 24th, 2023, at Duxbury in the County of Plymouth, did assault and beat Cora Clancy with the intent to murder her, and by such assault and beating did kill and murder said Cora Clancy on offense 001 on the charge of murder. How do you plead guilty or not guilty?
Not guilty.
On offense 002, for the Commonwealth of Massachusetts on their oath present that Lindsay M. Clancy of Duxbury in the County of Plymouth, on or about January 24th, 2023, at Duxbury in the County of Plymouth, did assault and beat Dawson Clancy with intent to murder him, and by such assault and beating did kill and murder the said Dawson Clancy on offense 002 on the charge of murder. How do you plead, guilty or not guilty?
Not guilty.
On offense 003, the jurors for the Commonwealth of Massachusetts on their oath present that Lindsay M. Clancy of Duxbury in the County of Plymouth, on or about January 24th, 2023, at Duxbury in the County of Plymouth, did assault and beat Callan Clancy with intent to murder him, and by such assault and beating did kill and murder said Callan Clancy on offense 003 on the charge of murder. How do you plead, guilty or not guilty?
Not guilty.
I believe we can waive the
You can.
for this.
On offenses 004, 005, and 006, all charging strangulation or suffocation of another person. How do you plead, guilty or not guilty?
Not guilty.
Thank you.
Yes, Your Honor. I'm also requesting that of bail based on the facts of this case and the potential penalty As to the facts, Your Honor, on Tuesday, January 24th, 2023, Lindsay Clancy, the defendant before you, interacted with many people both in person and over the phone without any problems or cause for concern. She was able to take her 5-year-old daughter Cora to the pediatrician. She was able to play with Cora and Doc.
Just to let you know, the signal feed is on their side, nothing to do with my side. It is all the way up to the top. So if you're having problems listening to it, I suggest just to turn your volume up on whatever device you're listening to this.
3-year-old son in the backyard that day. She was able to take care of Callan Clancy, her 8-month-old child, without any problems or concerns that day. She was also able to call CVS, or local CVS manager there, for Cora, without any problems. She was able to select a place for dinner online, 3-week restaurant. She was able to communicate that to her without any problems. She was able to call the restaurant, place the correct order, give her husband's name, give her husband's phone number without any problem. She was also able to check Apple Maps, where she was able to determine how long it would take her husband to get from her house to the restaurant and back, so she would know how long he would be gone approximately. She then sent her husband off to CVS with medication and to the restaurant. Patrick left the house that evening at 5:15 p.m. He said goodbye to his wife, he kissed his children, he returned home at 6:09 p.m. He was only gone for 54 minutes. The defendant's phone shows that while Patrick was at CVS, he called Lindsay at 5:33 p.m. and she didn't answer the phone. She called him back at 5:34 p.m. and he said the conversation was fine. They were discussing medication, so she did seem like she was in the middle of something. Now, surveillance footage shows that Patrick got off the phone and went to the register and checked out at about 5:37 p.m. He then went to the restaurant while he's seen on here or there. He leaves the restaurant at 5:55 p.m. Immediately after the phone call from Patrick, Lindsay Clancy's fitness app on her watch, which is connected to her phone, shows that she went up 3 flights. In her home, there was the finished basement level, the first floor level, which is the living area, and then the second floor level, which is the bedroom area where her bedroom was. And it shows that she went up those 3 flights immediately after the phone call from where she spoke with her husband. When Patrick arrived home, the first thing he noticed was silence, which is unusual with 3 small children in the house. He did not see or hear the defendant or the children. He called her at 6:09 p.m., called Lindsay, and she didn't answer. So he went upstairs to their bedroom, which was locked. He was able to unlock it, and when he went inside, he saw that there were blood drops on the floor in front of a folding mirror. There was an open window. There was what appeared to be a bloody knife on a nightstand next to a wine tumbler that read, "Because kids." He then went outside and found Clancy on the.
So her husband didn't look out of the open window just to check she was on the ground outside. I mean, to me, that's the most natural thing someone would do. You know, if you walked into a bedroom or any room, saw blood on the floor, and then maybe a weapon like a knife, and then an open window, you would automatically go to that window and look outside. I don't think you would just look at it, turn around and go outside. I think you would look outside first, or in my opinion, that's what I would do.
Ground underneath the window that she had gone out of. She had cuts on her wrists and neck that were no longer actively bleeding. He called 911 and they asked him to put pressure on it. The wound, he said it wasn't necessary because they weren't bleeding. She told him that the kids were in the basement, according to Patrick Lindsay. When EMS arrived, asked him to stay with her, and he went into the house. The 911 call kept going. And in the 911 call, you can hear Patrick Clancy go into the house, go down the basement stairs, and we know he went to the right first, where the exercise room and the home office were, because you hear him screaming. And you hear him say, "Dawson and my buddy." And he takes the exercise band from around Dawson's neck, and then he goes to the other side of the basement where there's a den. And you hear him find Cora, and he screams, "Baby," and he's screaming. Then you can hear when he finds Callan. because the pain in his voice gets worse. The emergency people come downstairs, all the police, firefighters, yells, "She killed the kids." They're able to get to the children, get them into ambulances, bring them to the hospital. 4 in Dawson are declared deceased at the hospital. They died from asphyxiation. Callan was med-flighted to Boston Children's Hospital because they were able to get a pulse, but unfortunately he was brain dead and taken off life support several days later and died from complications from asphyxiation. The defendant was transported to South Shore Hospital and then later to Brigham and Women's Hospital. She sustained broken ribs, some broken bones in her back, and a spinal cord transection at the T5, T6 level. She also had minor scratches on her wrist and neck. On each wrist, there were scratches and a couple small puncture wounds. She did not split her wrists or slice them open, and the puncture wounds were not connected in any way. On her neck, there were scratches and one small cut that did not require stitches. The police were able to find several notebooks in the defendant's home pursuant to a search warrant that she used as journals, as well as some notes on her phone. And they detailed the months, weeks, and days leading up to this incident. She details her life, her children's lives, her mental state, what medication she was taking. Her writing was clear and precise and articulate. In one journal, she's even leaving notes for the nanny. Her 2 older children were going to school 4 days a week, and they had a nanny to help with the baby. And she wrote very clear and detailed instructions for the nanny in that journal. In these notes and journals, she always appears to know who she is, where she is, what's going on, what's happening. There's no disordered thoughts or speech, no mention of hallucination or any delusions. She did write the day before killing her children that she had, quote, a touch of postpartum anxiety, end quote, around returning to work. She talks about her psychiatrist prescribing medication to help her. She was initially diagnosed with generalized anxiety disorder. She was then evaluated at Women and Infant Center for Women's Behavioral Health in Rhode Island, who determined that she did not appear to have postpartum depression and told her to seek the help of a generalized psychologist. She wrote in her journal that she had suicidal ideation at times in December of 2022. She told her husband she had thoughts of harming herself and on one occasion of harming the children, but she did not write those thoughts or voice those thoughts again after a brief stay at McLean Hospital. She had called her treating therapist.
I'd just like to say I've seen people with various different types of anxiety, depression, and things. And some people I know have just had thoughts of like doing harm to a child or doing harm to themselves or harm to someone else. You know, like someone once said to me, I feel like harming XYZ, but it's just a thought. It's never materialized into anything real. So I believe in sort of like these depression states that you can still have intrusive thoughts, but you wouldn't act on those thoughts. Whereas some people, like with the postpartum depression, have those thoughts and they act on those thoughts as well. So there's 2 different cases there where people get intrusive thoughts, don't act anything, it just stays all in their head. And then you get people like Lindsay, where she had the thoughts and she acted on them as well. And by her trying to unalive herself, she's actually caused more harm to herself because she's now paralyzed. And I think she spent quite some time in hospital as well. So I just want to point that out about the different sort of like types, how people can feel with depression and things.
She had those thoughts and had herself admitted to McLean Hospital on January 1st, 2023. She was discharged from the hospital on January 5th. When she was discharged, the hospital did not file any paperwork attempting to have her committed as a danger to herself or others. When she was discharged, she denied having any auditory or visual hallucinations. She denied any homicidal or suicidal thoughts. She also kept a pretty detailed medication diary where she detailed the medication she was taking and the dosages and what was prescribed to her. And if she had any issues with each medication, she detailed how her doctors would take her off that medication or wean her off if there was an issue. She was never on more than 4 to 5 medications at a time. And at the time of the murder, she was prescribed 3 medications. According to her journal and notes, she was taking medications as prescribed. Dr. Dow, EAU, a psychiatrist retained by the Commonwealth, reviewed the defendant's medical records, prescription history, her journals, and didn't find anything out of the ordinary in the manner of treatment or in the medications that were prescribed to her by her providers. She testified at grand jury that the trial of different medications and different combinations and dosages is routine medical practice when initially treating a patient and trying to find out what works for them. Dr. Dow also reviewed the South Shore Hospital, Mass State Police Crime Lab, and NMS Lab's toxicology analysis of the defendant's blood that was taken from her at 8:18 p.m. on January 24th, 2023, the day of the incident at South Shore Hospital. Dr. Dow explained that a therapeutic level of medication is the level that's helpful to a patient but not toxic, and not below the level where it wouldn't have any effect. The defendant's blood work showed she had the following medications in her system. Amitriptyline, which is an antidepressant. The level was unknown as it was only detected by South Shore Hospital, and what Dr. Dow testified to was that different labs have different thresholds, and the drug level has to meet that threshold in order to show a positive. So it only showed a positive at South Shore Hospital. Ativan, which is a sedative, she had 61 nanograms per milliliter in her system. The therapeutic level for that drug is between 50 and 240 nanograms. So the defendant was at the low end of the therapeutic level. She had Valium, which is another sedative. She had 28.8 nanograms per milliliter. The therapeutic level for this drug is between 200 and 2,500 nanograms. And so she was at the very low end for that medication of the therapeutic level. She had Lamictal, which is an anticonvulsant in her system, 6.1 milligrams per milliliter, and that was at a therapeutic level. She had Trazodone, an antidepressant and sedative in her system. That level was 0.44 milligrams per milliliter. So that was below the therapeutic level, where it wouldn't be expected to have an effect on her at all. She had Remeron, an antidepressant in her system at 200 nanograms per milliliter. This was at the therapeutic level of a high dose. And then the final item was the only one that was at a toxic level, which was Seroquel, 1,800 nanograms per milliliter. And Dr. Dow explained these results to the grand jury. She said that the defendant had therapeutic levels of Ativan and Valium in her system. She had a low level of Trazodone in her system that indicated she had taken that dose the previous night. The defendant also had therapeutic levels of Lamictal and Amitriptyline in her blood work. The 2 medications that were present at a higher level, the doctor explained that they were at peak levels in her blood, which would mean that she took that medication approximately 2 hours before the blood was drawn at 8:15 p.m., which would put that around 6 p.m. This would mean that the defendant took this large amount of Remeron and Seroquel after she killed her children. We know this because she went upstairs at approximately 5:35 p.m. after the phone call with her husband. Her fitness app shows her going up those stairs. It does not show her going up those stairs again. So she remained on that level. Her husband left at 5:15 p.m. She brought the children to the basement and killed them, took a phone call, answered his questions without any problem, and then went upstairs to her room. Also reinforcing this is that Patrick Clancy returned home at 6:09 p.m. and the defendant was already on the ground in the backyard. According to Dr. Dow, the medications present in the defendant's blood could have the following effects on a person's body at those levels: drowsiness, confusion, sedation, hypertension, loss of coordination, seizures, or coma. She testified that the 2 worst things that could happen with these medications would be cardiac arrest or coma. She was asked if these medications and these amounts could cause a person to become violent. She said no. She was asked if these amounts could cause psychosis, if there were any studies that showed that they could cause psychosis. She said no. There was 2 case studies that detailed experience with Remeron, but those are just 2 individual patients self-reporting that there were no formal case studies on. Seroquel, the one that she had the highest amount of, is actually an antipsychotic medication prescribed to treat or prevent psychosis, so it would clearly not cause psychosis. On the night of the killings, Patrick Clancy was interviewed by the police at the hospital. He told the police that the defendant was having one of her best days. She was smiling and happy. There was no indication she was going to harm the kid. and no one described her as acting like a zombie in the days leading up to the murders or on the day of the murders themselves. She consistently denied hearing voices or having any type of visual or auditory hallucinations to all her treatment providers leading up to this incident. The first time she used psychosis was when she was with the doctor hired by the defense and using his phone to call her husband from the hospital. This was the first time she told someone she heard a voice. She has denied hearing this voice since killing her children. The defendant wrote a note on her phone on October 25th, 2022, stating, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby." She also wrote, "I want to feel love and connection with all of my kids." This would indicate that she did not feel love or connection with at least some of her kids. She then wrote she wants to have more kids eventually. 4 days prior to killing her children, the defendant did an internet search on her phone, and it was, quote, "Can you treat a sociopath?" The children were killed with ligature strangulation. Ligature strangulation causes the victim to become unconscious anywhere from 10 seconds to a minute, and that depends on how much the victim struggles or fights. The more they struggle or fight, the longer it takes. Dawson had the most petechiae on his face and neck. According to the medical examiner, this means Dawson either struggled or fought for his life more than Cora or Callan were able to, or that she strangled him harder than the other two, or both. And it takes 10 pounds of pressure at minimum to strangle. After the victim becomes unconscious, the ligature has to be held in place with that same force for an additional 4 to 5 minutes. She had to strangle the kids to unconsciousness and then keep strangling them for additional minutes. She could have stopped at any time. She could have changed her mind at any time. She could have helped them at any time. She did not. Instead, she finished strangling the children, returned her husband's phone call, then went up to the bedroom on the second floor. There she used the knife to inflict superficial cuts and scratches to her wrist and neck. She took the remaining pills of the Remeron and Seroquel, and then she climbed out of the bedroom window and gripped the windowsill while dangling from it. We know this because there's blood on the outside of the windowsill where her wrist would be in her hand. She then dropped from the window or slid down. She did not jump. She did not hurl herself out the window because there's blood on the exterior shingles going down the exterior of the house. And then on the window, directly below the window she came out of, there's more blood on the top level, looking like she tried to grab onto that windowsill. So she lowered herself out the window and dropped down. Don't think she took into account the fact the ground was frozen. The defendant did not take advantage of the situation when her husband went out that night. She created. She used Apple Maps to make sure she'd have enough time to do what she wanted to do to the kids before her husband returned. While being treated at Brigham and Women's Hospital in Boston after killing her children, the defendant spoke to medical staff. On February 6th, she said that she had fears that her inability to walk would make her vulnerable to others, and that she was worried about not being able to walk again. On February 7th, she said she was feeling more hopeful about her future. On February 8th, she stated that she was more future-oriented and hopeful. And on February 9th, she was visibly engaged, energized, and hopeful. She is a danger to herself and others. She planned these murders. She gave herself the time and privacy to commit these murders, and she killed these children in their home where they should have been safe. She did so with deliberate premeditation and extreme atrocity and cruelty. At least as far as February, she was showing no remorse and being hopeful. But after you hold it without that.
Thank you. Mr. Reddington? Yes, sir. Thank you. First of all, as you're more likely is aware, Ms. Clancy is a nurse, obviously a wife, mother. According to anybody that you speak to prior to this incident, she was nothing less than a marvelous, incredible mother, housewife. I've been in that house. There are photographs that show the love and devotion that both Lindsay and her husband Patrick had these kids. Every single room was covered with her artwork, embroidery, pictures, statements for the kids, charts and graphs of how they're doing or what they're doing as far as learning. alphabet, numbers, things of that nature. She then, after having the third child, obviously, and I understand that the government wants to portray lack of criminal responsibility as somebody who is crazy, as we would envision somebody being crazy, unable to speak, unable to take care of themselves with hygiene, acting in a very, very irrational fashion. But that's not what happens when you have a situation as here. You have a woman who is obviously suffering from postpartum depression. And how do we know that? Well, we know that because in the weeks and months prior, she was in such a state. She was unable to emote. She was unable to feel. She had no ability to love, whether it was her husband or her kids, and she told Patrick, her husband, that. Patrick is the one that went to the doctors and told the doctors that she was acting as a zombie. And it's interesting that the government was able to get medical records from these doctors as soon as they snapped their fingers. I had to file a Rule 17 in the district court. I sent out the order to the doctors. Some of them responded. Interestingly enough, the ones that were prescribing the medication, they lawyered up. They wouldn't even talk to me. I got letters from lawyers, most unprofessional, telling me, do not talk to my client. And then when my office manager, Laura Mather, was reaching out to these people, asking the lawyer, where are these records? He didn't even return the phone call. Not once, not twice, but 3 times. So now the grand jury has the medical records. But I was finally able to get the Rhode Island hospital record. One appointment. It's a joke. One appointment she has. And they say, oh, no, she doesn't have postpartum. No, she doesn't have the symptoms of postpartum. But she was in such a state as a result of the postpartum as well as the medication that she was on, that her husband had to have her mother and father and his mother and father basically stay at the house for weeks, perhaps a month prior, because she was unable to function. And he had to work. He worked out of the house, but he also had to leave the house. So this is the condition that she was in at the time leading up. And she was taking these diaries because she was told by her doctors to be very, very accurate. Write in the journal what medication you're on, how much, what's the dose, what, if any, reaction do you have? And she was faithful to that. She's an intelligent woman. She's a registered nurse. She knew how to take notes in a journal. That does not mean or indicate that she was not suffering, because obviously she was having problems with the medication as a result of which they told her to keep a journal. And it's the same thing as Patrick going to the doctor and telling the doctor she's a zombie, and the parents staying with them to help to take care of the kids. And the fact that that day he was able to talk, communicate, build snowmen with her kids, talk to her husband, make plans to have dinner, go out and get the dinner. This is not some nefarious plan where she's going to Google how long it's going to take to drive to a restaurant that they've been to, that they know where it is. As she's planning, and as a result of that, she then speaks to him. So I guess she must have been fine because she was able to communicate with her husband about the purchases of the items in the drugstore. When I was in the house, I was able to see the blood that was on the floor, on the wall, on the window ledge. And it was fairly copious. It's not some kind of little superficial, little dinky, little scratch on her wrist and on her neck. There was blood. It looked like arterial spray, actually, because it was on the floor, droplets all over it, and, as I say, on the wall and on the window. She fell out the window, obviously, not anticipating that she's going to, in some fashion, slide down the house and pretend that she was suicidal. She obviously hit the ground, transecting her spine, notwithstanding for months the police making comments in the news media and the government arguing. And in good faith, I would never suggest that these attorneys would ever misrepresent something. But everybody was taking it like, oh, she should be fine. Should be fine. She's not going to be fine. She's permanently paralyzed. Dr. Philip Resnick, who was a world-renowned psychiatrist, has examined her and is on our team. Dr. Paul Zeisel is sitting here, has been with us on this matter from the very beginning, once I get involved with the case, with the family. she obviously had no reason to kill those 3 beautiful children. You have to ask yourself, why? Why? And when you ask yourself why, and you consider all of these factors, it's readily apparent, I suggest, Judge, that this woman was a troubled soul. So when the case goes to trial, I believe she has a very, very, very good defense, a very strong case. But we know that she is a danger, as counsel agrees, to herself and perhaps others. I don't see danger to others, but she certainly is a danger. So she's been hospitalized, as you know, from South Shore Hospital. She went to the Brigham and Women's. She was at Brigham and Women's in the Lockwood. She had police officers stationed outside her door. Then from Brigham and Women's, she went to Spalding Rehab. And now here we are in Tewksbury with the Department of Mental Health. All this thing has filed under 18A, 123 18A, indicating that she needs hospitalization. She does not need jail. She does not need Framingham or Plymouth House of Correction. I do believe, and Your Honor is aware, that she has been evaluated by the court clinician. I fully expect that DMH will file a request under 18A, ultimately seeking that she be held here pending trial. So I'm asking that you not hold her without, but as far as holding without bail, but with an order of the court that she would reside here at Tewksbury Hospital.
Has there been a petition filed regards to the?
I know that there was evaluation this morning, right?
Yes.
I just don't know.
Under 18A and a half, I can. We can have a hearing in regards to the need to commit her is an allegation of serious harm to herself. And so the doctor has, the clinician has interviewed her?
Yes.
And is she prepared to, what do we know?
She's on. Oh.
Yes, Your Honor.
All right, Dr. Gus, I'm sorry, I couldn't tell who was. So did you have an opportunity to interview Ms. Clancy today?
I did, Your Honor. I interviewed her via Zoom earlier this morning.
Okay, can you tell me what your the results of that interview?
Yes, Your Honor. So Dr. Karen Towers, court clinician, designated forensic psychologist. I did meet with Ms. Clancy via Zoom earlier today. I had previously had a brief conversation with her social worker from Tewksbury Hospital yesterday. And I'm aware that the clinicians at Tewksbury believe that she does require continued hospitalization at this time. I also did review the Section 18A evaluation that was completed at the hospital in dated April 26th of this year, following her initial commitment there under Section 18A for evaluation. When I met with her this morning, she reported to me that she continues to have feelings of depression. She reported feeling unbearably depressed, struggling to get through each day. She presented with flat affect, little to no emotional expression. She did report that she has been experiencing intrusive thoughts and flashbacks on a daily basis. She's had difficulty sleeping, poor appetite. She indicated that she continues to experience feelings of hopelessness and worthlessness. She reported to me that she does have ongoing daily thoughts of suicide, although no specific plan in place, but she indicated she has thought about ways that she might try to harm herself. She did not present as overtly psychotic. She didn't present with any overt delusional ideation, denied any current experience of hallucinations, but again, did present with and did report ongoing feelings of depression, anxiety, hopelessness, worthlessness, suicidal ideation. Based on her current presentation, which is consistent with my understanding of how she has presented during the course of her hospitalization at Tewksbury, it is my opinion that she does require ongoing psychiatric hospitalization. She indicated to me that she remains on one-to-one observation status due to ongoing concerns about her risk of harm to herself. So I would recommend further further hospitalization pursuant to Section 18A. I have been informed that in the event the court is inclined to remand her to DMH custody at Tewksbury Hospital under Section 18A, if there are no objections from any of the parties, Tewksbury would agree to accept her as a straight 18A commitment for a period not to exceed 6 months without the need for additional 30-day evaluation. So the hospital is prepared to do that should there be no objections by any of the parties. Otherwise, the court could certainly order her there for another evaluation under 18A for the 30-day period of evaluation.
All right, Doctor, thank you very much.
You're welcome, Your Honor.
All right, well, I'm going to make a finding that Ms. Clancy has serious risk of imminent and serious self-harm. So I'm going to make that finding. And so is there any objection if I order a commitment under 18A for the extended period rather than 30 days? Como?
Your Honor.
Bennett?
Of course, thank you.
All right, so I'm going to issue that, so she will be held without bail, without prejudice. She'll be committed under 18A, relating to the findings that I made.
Okay, thank you.
And do we have a next date?
We do, and I just wanted to file a formal statement of facts and our first notice of discovery, and I have a copy for it. Are you ready? Do you want to keep the November 30th date? Or do you
No,
want-
I was excited to be in Lowell, so now that we don't have to have that constraint, yeah, how about, can I ask for a February date?
I would ask for something earlier. I want to keep discovery on track.
Yeah, why don't we do that? We can waive the defendant's appearance and pick a date, just because it sounds like there's going to be significant discovery.
I'm gonna be with you on the Callahan case on December 13th, so that'll be for at least a week. So, in the afternoon, perhaps.
Call it any of those days. Can we work for you?
Any day that week is fine.
We'll do it a little bit later towards the end of the week. We're dealing with impairment.
Sure.
That Wednesday, Thursday.
Confirm with that Wednesday.
Oh, so that's a Wednesday. Well,
Right.
we're going to go into the next.
Do you want to say 15th is Friday?
Fine.
All right, so this matter will be continued to December 15th. And its presence waived on that day, so we'll see the parties. That day.
Very good.
All right.
Thank you, Lindsay Clancy. On this indictment, the court orders that you held without bail, this will be set without prejudice, and that you're going to be under the agreement as made by the parties. Matter is going to be continued to 12/15/23 at 2 o'clock in Plymouth. Thank you.
Mm.
Presence is waived.
Thank you.
All right, thank you, Council.
Thank you.
So yeah, so there's that one. I'll just see if there's any others I can bring up. Where was my list gone? A minute, bear with. I had a list on there earlier. Bear with me. Latest on Lindsay. Let's see. While I was looking for the depression stuff, I completely got rid of my list. When was the latest? Let's go to the videos. February 23, 2 months ago. Bear with me a minute. See if it's in my list. Right, so we did. So this was 2 months ago. A minute, bear with me a minute. Let's get rid of that one. Come back to that one. This is 40 minutes long, so this is going to be a really long video, guys. I won't necessarily have my face up there because I've just got to go and make a drink and that. So I will be listening because I've got the headphones attached to my head. So you can't get rid of me that quick. Right, let's put it on full view.
Morning again, Your Honor. Good morning, all. Before the court is the case of Cumwell versus Lindsay Clancy, 2383 CR 198. Just looking to see if we have Ms. Clancy in the Zoom. Just a second, Rich. Yeah, Ms. Clancy appears to us by Zoom. Counsel for the record, please. This case is called for motions. Cumwell first.
Yeah, good morning, Your Honor. Jennifer Sprague for Commonwealth.
Attorney Sprague, good morning.
Good morning. I believe Attorney Kenny is on her way upstairs now.
Okay, all right.
And Shannon Buckingham also for the Commonwealth.
Attorney Buckingham, good morning.
Morning, Your Honor. Kevin Reddington on behalf of Lindsay Clancy, who, as you know, is on the Zoom with us.
Mr. Reddington, good morning. Ms. Clancy, good morning. Can you hear me all right?
Good morning, yes, Your Honor.
Okay, thank you. All right. So this is really kind of a continuation of the discussions that we had yesterday. And what I wanted to do was kind of give you where I think we're going to go, and then I see that we can go right. One of the first things I want to talk about again is transportation and logistics issues, how we're going to do that. Then I want to go over medical records, kind of where we are in regards to discovery. Then I want to kind of see where we are in regards to the examination of the defendant by the Commonwealth's expert. And then I know there's a Rule 17 motion we have to talk about, and then talk about other needed dates before the trial. And the last thing that I will probably mention, so everybody has in their head, is the date to provide an updated joint pretrial memo, because I think that's going to be very helpful, at least for the court, in regards to preparation. And so I think the first thing that I would suggest bringing up is the transportation and other related issues in regards to it. I know we talked a little bit about that yesterday, but that was more, I think, in the frame of it being an emergency issue about whether or not Ms. Clancy was brought in today. We can now kind of take more of a deep breath and talk about kind of where we go. I know they saw Attorney Kenny's here as well. And so why don't I hear from Attorney Kenny, if we would, as to what kind of what the Sheriff's Department thoughts are, or proposed plans or procedures, how they would follow in a case like this.
Good morning, Your Honor. Jessica Kenny on behalf of the Plymouth County Sheriff's Department. As I represented to the court previously, we were forwarded the HABE to bring the defendant to court in this matter a couple times previously. It gets sent to Tewksbury, but because she's also held without bail on the murder charges, Tewksbury sends that to us. I originally thought that that might have just been because of the murder charges, but as I learned and explained to the court yesterday, I apologize, I have a cough drop in my mouth. I just have a little cold, so I didn't want you to think I was eating food.
I kind of pulled you right out of the audience.
That's okay.
Unexpected as well. Thank you.
As I learned yesterday, it's also essential because Tewksbury Hospital doesn't have the ability to transport, nor the security to be able to do it either. So as I indicated previously, the last time we were sent a HABE for her appearance, we received that from Tewksbury Hospital with a note that her medical information would follow. It did follow with a fax from Tewksbury that explained the nature of some of her medical needs. In light of receiving that fax, the transportation supervisor reached out to me and to our HSA, who is our health services administrator, and asked for a little bit more information to make sure that we could meet all of her needs. So our HSA, who was in court with me on the last date, did reach out to Tewksbury Hospital and spoke with someone there who provided just a little bit more background information about the medical necessity that would be required. And based on that information that we received, we understood that we could transport her in a van that we have that has been equipped to hold a wheelchair. It's a regular transportation van that we had, and about a year after we purchased it, we had it outfitted by a company specifically that does that to make it so that it can be used or utilized with a wheelchair. We had also indicated that based on the information we received from Tewksbury, we had no objection to sending a nurse along with Ms. Clancy. The information we had received from Tewksbury was that, likelihood she could handle any care matters that came up, but in the event that she did need some medical assistance, we thought it would be prudent to send a nurse along with her for that transportation. And so that was our plan based on the information that we had from Tewksbury. Obviously, since that occurred, I have received from Mr. Reddington an ADA request that he filed with the court with documentation from a psychologist, I believe, that has been seeing Ms. Clancy, that indicates that any sort of custody situation would create a sense of helplessness and loss of control that could trigger some mental health responses from her. I'm also in receipt of a 2-page letter, I believe it was just yesterday or Monday, that was forwarded to me, that instead indicated that she may actually need a stretcher and that she would need 2 nurses to accompany her. And it had some more detailed medical information. So before I had received those, like I said, based on our communications, that was our plan. That's all the information that I have regarding that. I only obviously have what Tewksbury shares with us and then what I receive from her counsel separately or from the court in pleadings. If it is still the case that Tewksbury believes she could be in the wheelchair van, we are able to do that. If she requires an ambulance, I've spoken to our transportation officer about this. It's a much bigger ask. We would have to contract with a private ambulance company to provide that, because we do not have an ambulance, and Tewksbury does not have an ambulance. So there would be certainly a cost associated with that. There's also some logistics, is that the scheduling of an ambulance obviously can sometimes be a difficult thing given the nature of what ambulances are. I don't know if we would require the court would require the ambulance to stay at the courthouse the entire time that Ms. Clancy was here each day to make that stretcher available to her if she needed it. If the ambulance were allowed to leave, it would then require the trial court officers to reach out to the sheriff's department, to reach out to the ambulance company to send the ambulance back. And obviously that would have to occur if that's what the court rules that she needs for transportation. That would require us to arrange that every day of her trial for the duration of that trial. So we do not have another way to transport her if it's not in a van that can accommodate her wheelchair.
All right, thank you. Let me ask if, in regards to the information you received from Tewksbury, not considering the psychiatric concerns that were raised in a separate motion, would the Sheriff's Department be able to provide the care or the supervision that was kind of spelled out in that letter from the other day?
So that letter from the other day seems to indicate that she would need a flat surface such as a gurney, I believe was an example. So we don't have a van that could accommodate a stretcher. So if she needed that during transport, it would be an ambulance. If it was a matter of getting a stretcher to the courthouse so that she had it here available, I can talk to our facility about whether we have some sort of medical bed that we could make available to her here. If she requires if the court finds that she requires 2 nurses, obviously that's a little bit more of a strain on our staff, as we would be then required to pull 2 nurses out of our medical unit in the jail. So I did actually briefly mention yesterday when I was speaking to the attorneys from Tewksbury if maybe they would be willing to split that with us, and maybe if they may be able to send a nurse from Tewksbury and we would send one from the House of Corrections, so there could be two, but neither of our, because they also expressed concern about pulling two nurses off of their floor as well. And I know they're at least open to the idea of talking about it. It would probably involve conversations with the attorneys from DMH, because there are some.
See, to me, she's paralyzed from the waist down, I believe. So why does she need to have like a stretcher? Surely she could be transported using a wheelchair. And I'm sure wheelchairs can be adapted so they're a bit more comfortable, like with back padding or pillows, or even like a hospital type chair. I don't see why she necessarily needs like a stretcher to lay flat on. I can understand if she's in court for a long time, she might need to lay down, but how do other people that are, you know, paralyzed from the legs, waist down, cope on a day-to-day basis? I'm sure they don't lay down all day long. I could be wrong in this case, and my opinions are my opinions. But it's just a thought process. Or unless she's doing this to just be a little bit difficult. That is another possibility. Because I'm sure while she's in the jail, she's not let down all day and that, but we'll see. We'll find out. I tried to see if I could speed up the sound. Voice boost, playback quantity. Yeah, I was trying to speed up the sound because at the moment we're on, let me just get rid of this. We're currently on 1 hour 26 minutes, and this is 10 minutes into it, and it finishes. When does it finish? 39. So we got over 20 minutes or so of this one. That's why I wanted to try and find a way to speed up the audio on it so she's speaking a little bit faster. But if I can find it, I'll find it. So if you see her speaking a bit faster, you know why.
Union and labor issues that we would just have to work through individually with the individual departments. But I don't, it wasn't foreclosed when I brought it up yesterday. If the court does order her to have two nurses with her, perhaps one could come from the House of Correction and one from the hospital setting, so that neither is really shorthanded. I know this will probably be a lengthy trial, if I understand. And so it's just it can be done, but it would just take some planning. That's all. We're hoping to get an order from the court well in advance. So
I was going to say, an advance order would be...
Yes, especially if there's going to be an ambulance involved, because in fact, yesterday we tried, in case the court didn't allow her to appear on Zoom today, we tried to see how we'd be able to get an ambulance for today. We had struck out on all of the attempts that we had made. So advanced planning is key if there's going to be an ambulance involved and if there's going to be more than one nurse involved.
Okay, fine. Thank you very much. I appreciate the input. Mr. Reddington, what suggestions or proposals would you suggest the court implement in regards to the transportation, as well as while Ms. Clancy is here during the trial date?
That whole presentation is, as the old song back in the 70s, is Radio Gaga. It doesn't tell you anything. The last time that counsel for the sheriff addressed this court, I got off of FTR, the representations that were made to this court, that led to my filing the Rule 17 motion, which I think is central to the issues that you, and I don't envy your job, because this is a nightmare. This case is going to be a logistical nightmare. When you consider the facts that, number one, we have a person who is paralyzed and will be paralyzed for the rest of her life and has lost any sensation in any motor control whatsoever. And I am referring to the January 2nd, 2026 letter that I obtained from the physician's assistant who knows Ms. Clancy, who has been involved very, very deeply with her treatment and care, indicating that she lacks both sensation and motor control below the sternum, breastbone. When we had our hearing and counsel for the sheriff made representations to you, first of all, one of the things that was said is that it would be currently the sheriff, health services administrator, and I quote, reached out to the medical team there and learned that Clancy is confined to a wheelchair. However, she can self-transfer and can provide self-care in virtually all aspects of a day trip like this.
Exactly what I was saying, wasn't it? That, you know, she can be in the wheelchair. I think they're just making it difficult. I hope I've not sped this up too fast for you, but I just thought to pain you from, you know, like nearly a 2-hour video to watch.
This to the courthouse, a day trip like this to the courthouse. The only thing Tewksbury was requesting was that we transport her via wheelchair van, which we do have one of those vans available. Which begs the question, first of all, as my Rule 17 motion, I did an investigation, and I don't know who the heck they talked to from Tewksbury, but that's not the information I'm getting from Tewksbury. So I filed a request. Number one, I want a copy of the signed HIPAA form. That is a law. It's a federal law. We all know it, and it means something. That a person has to sign an authorization before people can willy-nilly make phone calls and talk to people about somebody's physical condition, mental condition, dealing with medical records and things of that nature, which apparently was done here. There's an awful lot of representations made to the court about someone from Tewksbury.
Let me stop there. What if, I think some of those representations and positions were made before the December letter from the physician's assistant. And if I have that information from that letter that was provided by you to the court, as well as to the Commonwealth, my thought is that seems to be more representative of what the condition is. And I'd like to go forward. If I adopt that opinion, the question I'd have is what are the arrangements consistent with that medical condition that's set out in that letter? That's kind of where I'm at right now.
Understood, and I appreciate that, Your Honor. And facts and identification of the source of the facts are important here. You don't just reference someone from Tewksbury. In my Rule 17, I asked for identification of the person who is the health service administrator.
Just a quick update on housekeeping rules. You can click like, subscribe, and share. I would really appreciate it because it helps me to get into the YouTube's algorithms. And because I'm not monetized at the moment, because I'm so far away from what you need to achieve to be monetized, I do have a thing scrolling at the bottom where you can buy me a cup of coffee. And that's one way you can support my channel at the moment so I can get monetized, where I can do like subscriptions and give away free subscriptions and that to my members. So if you can, feel free to buy me a coffee. The link's at the bottom. All you got to do is put that into your web browser and it comes up to my page. All right, then. Thank you very much. I'll let you get back to listening.
Apparently, for the sheriff that spoke to someone from Tewksbury about the day trip to the courthouse. I don't know who it is that worked for the sheriff's department that talked to them in Tewksbury. As I said, I want to have in my order a copy of the HIPAA form that was signed by Ms. Clancy, which I know and it represents the court was never done. I want to know the identity of the person from Tewksbury who allegedly advises that she is capable of providing self-care in all aspects of the day trip to the courthouse and that all they wanted was a transport via wheelchair. You take that letter of January 2nd, that was addressed to whom it may concern, which unfortunately is you, because you are the one that ultimately has to decide the logistics of this case. And it is nightmarish. We are going to be in a situation where we have a woman who is paralyzed from the sternum down. Your Honor is well aware that she has no control over any of her bodily functions. Your Honor has the letter that describes in detail the requirements, and I know the letter's understood.
But if she is paralyzed, it's not like if she is. She's paralyzed from like the sternum down, so from here downwards. So she would probably have a catheter fitted. I don't know if she would have a stoma bag fitted, but she would definitely have a catheter fitted. But like he said, she's quite capable of seeing to herself on a day-to-day basis, transferring from chair to bed and vice versa. You know, so I am beginning to think they're trying to make it as difficult as possible, stating that she needs a stretcher, 2 nurses. I don't think she needs 2 nurses, probably 1 nurse, just in case she has a mental breakdown thing or whatever. But I had started feeling really sorry for Lindsay at the beginning of this because I know how depression can affect people. I've seen it and it's not nice. But yeah, I don't know now. Mixed feelings.
And just out of interest of trying not to get into embarrassing issues here, it's incredible the medical care that is necessary for the duration of the trial and periodically during the day. This is where it's advised to the court that she requires a 2-person female assist for these issues, necessitating transfers to flat surfaces such as stretcher or exam table. How the hell did she come up with telling you that she's able to ambulate and self-transfer and provide self-care in all aspects of a day trip like this to the courthouse, when you have this letter that tells you the condition that this woman is in, requiring two-person female assist for her care, that she has to be transferred to a flat surface, such as a stretcher or exam table. This isn't something that you got from the Sheriff's Health Services Administrator. This isn't something that you got from the lawyer for the sheriff telling you, well, we talked to somebody up in Tewksbury, someone from my office spoke to them. This is hard facts that we're dealing with here. So looking back at the letter, after the transfer to the flat surface, it has to be done on a regular basis. She then has other issues that have to be taken care of, as you can well imagine. She is not able to even use a handicapped bathroom stall. She has to have extra supplies available. She has to have a nurse that's not a veterinarian that knows what the medical condition of the individual.
Really? Oh, the
Sheriff's Department.
I do apologise for having some internet. I don't know.
We have raised the issue.
Their side.
To 12321.
Let me just unslow this down a bit.
A person who is mentally ill, who has been committed, if you will, to the care, custody, and control of the who's the sheriff? Illness,
I think they've got no problems. Or it could be mine, I don't know.
Purpose authorized under this chapter shall not use any restraints that are unnecessary for the safety of the person being transported or anyone likely to come in contact with the person. I've also requested ADA assistance. I researched into it and found that there is one form that is supposed to be used in the Superior Court in the Commonwealth of Massachusetts, or any of the court systems in the Commonwealth of Massachusetts. That form was provided by the committee, as Rhonda knows, that is dealing with the Americans with Disabilities Act. She's an American, she's presumed innocent, she has a disability, she comes squarely under the ADA. I filed the request with this court. Counsel for the sheriff indicated that I didn't ask the sheriff. I filed it randomly with the court. No, it wasn't randomly with the court. It's what was required by the Superior Court ADA. So I did file ADA, meaning Americans with Disabilities Act. I did file that request. So now we're dealing with 12321. We're dealing with the ADA. And it does apply to this court. So my suggestion, Your Honor, is that I need to know who it was that they talked to from Tewksbury, because I want to interview that person. I want a copy of the HIPAA form, which I know they don't have. And I want to know who the person is from the Sheriff's Department that made these representations to Attorney Kenny, because Attorney Kenny, I'm sure, is relying on what was provided to her. So you, I think, have to have a hearing. Now, a hearing might entail evidence from the physician's assistant. Maybe it would require evidence.
What I'll do, guys, because like I said, this is going to be like a nearly 2-hour video. I'll play this one and then I shall end the stream from here. And then if I find any more information on it, I'll do a part 2. And in the title, I'll put Lindsay Clancy part 2. And that. Okay, guys?
I don't know, maybe you have an independent evaluation. This whole thing raises issues of competence to stand trial. How's a person going to be able to go through the horrific emotion of this case for 3 to 4 weeks on a daily basis with these medical issues of significant concern, not to mention the fact, as is indicated again in the letter, which gives you the hard facts that we're dealing with, that she has significant suicidal ideation. That since she has been in custody, care, and control of DMH, and has been in Tewksbury, for example, she is on 24/7 watch by a third party. A person has to observe her. She cannot have access to anything that she could use to hurt herself. She's not a danger to others, that's for sure. But she's surely a danger to herself. So all of this, people telling you, well, Judge, we can put her in the lockup and we can put her downstairs and we can move her up to here. It's not on me. If this woman kills herself during this trial, which there is a very real probability that could happen, it's on somebody and it's not on me, because I'm coming in here with names, reports, facts, medical and psychiatric issues. And unfortunately, it all lies at your table because you are the judge that has to determine the logistics on this case. So that's why I think we need a full hearing.
Commonwealth, do you wish to address the court?
Yes, Your Honor.
and maybe do a full hearing via Zoom like she's doing now, then that saves all the logistics and trying to get her there, her safety, preventing her from trying to top herself again. So that would be the next reasonable step, I think.
So defense counsel referenced chapter 123, section 21, but what it states in the very beginning of that statute is that it applies only to the transport for any purpose under that chapter 123. So that's basically someone committed under chapter 123, and you're transporting to court to address those issues. This is clearly not that situation where she's going to be transported for a murder trial, a criminal case. So I suggest that the items listed in that statute describing how and when you can have someone confined or restrained don't apply here. In terms of the HIPAA form that defense is asking for, this woman is a prisoner held without bail on these charges and is in the custody and control of the sheriff's department. So they have every right to access her medical information because they're responsible for her care and treatment and keeping her safe, which they have done an excellent job up until now, and I assume they will continue to do so. Now, the letter from the physician's assistant dated January 2nd, 2026, never states that Ms. Clancy has to be transported in an ambulance. Never says that she has to have a stretcher for transportation. What it says is for bathroom needs, she requires the 2 females and a flat surface such as a stretcher or an exam table. So I think that the initial what's in this letter and what was initially described to Attorney Kenny is correct, that she could be transported in a wheelchair van, but we now have the additional information that we need to medical staff present and some type of table, which I think we could probably rent something, you can rent medical equipment, so I think the court could arrange that, or the sheriff's department, however you order it. And the defense had mentioned how Ms. Kenny was able to come up with this information about Ms. Clancy being able to take care of herself. It's right in this letter from January 2nd. It says Ms. Clancy is able to independently transfer between her wheelchair and her hospital bed. So she is capable of transfer and movement, and that is what Ms. Kenny said. We now have this new information about bathroom needs, but that can be accommodated. So I don't think there's any reason for the drama here. There is no need for.
Just thought of something. Don't most buildings in America and places and other states have disabled access toilets? Over here in the UK, pretty much every building you go into does have a disabled access toilets. I don't know about our courts over here, but I'm pretty sure they would have to accommodate someone with disability needs. And, if they have got a disabled toilet there, then there'll be rails for her to hold on to while she transfers from the chair to the actual toilet and vice versa. Maybe need the help of one nurse, because obviously if you transfer and you do need to remove your clothing to be able to go to the toilet, that's if she's not catheterized.
Hearing here, you have the letter from the physician's assistant. An order can be crafted from that, and the sheriff's department can comply with that. So I think it would be good for everyone to just take a breath and make a plan and follow the plan.
I'd like to respond, Your Honor, briefly. I don't need to take a breath. What I am going to do is make reference to the letter that was just referred to, which is January 2nd, 2026, that I obtained and requested. And counsel just told you that the letter says that Ms. Clancy, and I quote, is able to independently transfer between her wheelchair and her hospital bed. But what was not said is the rest of the sentence, which is that she has not had significant exposure to settings outside of the hospital since her injury and would likely not be able to safely take transfers independently in unfamiliar settings.
Here's what I'm going to do. I'm going to craft an order based largely on the information that the court has received from the physician's assistant from Tewksbury. And so that's the starting point that I'm going. That's really the only information that I have from one of her care providers that sets out the condition as well as limitations that I have to take into consideration. So I'm going to draft an order, and I am going to distribute it to both council on this as well as to the sheriff's department. And we may need a follow-up hearing in regards to that if the sheriff department says we can or we can't comply with that, or if the defendant feels this doesn't address enough the issues that are set out. But I have a very specific report as to Ms. Clancy's limitations and needs. And I'm going to craft to the best that I can in order addressing the needs of transportation to and from the courthouse, but also how we handle the time that she's here, what needs she needs during the trial, and off times if she's in one of the cells. So I'm going to try and draft as specific an order. We've all tried a lot of cases. We know, I think I know kind of some of the things that can happen, and there's waiting time and there's downtime in regards to that. So I'm going to try as best I can, but I know I'm going to overlook something. And so I think it's going to require at least one more run of everybody come in and say, okay, what do you think? What's the problem that you see? Sheriff's Department, what's the problem that you see? It may require issues regarding staffing. And it may be, if I put in the phrase something like a qualified nurse, the question is what's qualified? That may be something we have to specifically address. But I want to get this done within really the next couple of weeks or so. Because the one thing I don't want is to have everybody here for trial and then have something that we just didn't foresee create a problem. I don't think that is fair to either side, and so I want to avoid that. And I think the best way to do that is for me to it's on me. I know, I understand that. For me to draft this order, circulate it between the parties, and then have one more kind of meeting here to say, do you see a problem? Do you see a problem? Sheriff's Department, do you see a problem? And then get that in place, that everybody can kind of figure it out. And if it requires getting a second nurse, and it requires phone calls, how we do that? Well, or not we, how they said it, or the getting a gurney or getting a stretcher that we can place in one of the cells on this floor, so it's not in the floors downstairs. At least then we can get going on that. That's not something we have to do the first day of trial. So that's what I'm going to do on this. I'm going to take a run at drafting this order as best I can, and then, but everybody should rest assured that that's not going to be the end of it. The parties will have an opportunity to kind of respond to it, and I would welcome suggestions. If someone says this is a better way to do this, or this is not addressing something we thought of, but at least it'll give us a starting point. And like I said, I have now a very specific report in regards to the defendant's condition and needs and limitations. So I'm going to take those into consideration. I'm also going to review it in regards to ADA compliance. I know that I have started to look into that in regards to that, but I think this may address those issues. So I want to make sure that the order I draft also is consistent with the ADA. So that's how we're going to deal with that. The next question that I had, there was some issues regarding some medical records from Tewksbury Hospital that I know we discussed maybe a couple of months ago. My understanding is that those records are now in, and it's also my understanding the original order was that both parties could have access to those records, but they are in at this place, as I understand. But I checked the docket, so that their parties, I signed a protective order today, so the parties can have access to them, and get copies of them. And so I don't know if that addresses that part of what we were talking a little bit about yesterday. Kamal?
Yeah, I think under the rule that the records were requested under, the experts requested them through the court, and they were supposed to be sent by the court to the experts, but I have a copy now, so I can send them. That's fine.
Yeah, I think that's probably the more efficient way to do it. Any objection to the Commonwealth sending those records to their expert?
No, of course not.
Okay. All right. So if you need an order allowing it, we can do that. But why don't we handle it that way?
Right, and you should know that I have provided the experts with videos, notes, data, reports, everything from my three experts.
All right. Well, that takes care of my next question.
I hate to go back to it, but will you consider allowing the request that I had in Rule 17? I'm not sure if you want to do that or not.
I'm not going to rule on that at this point because I think if we're talking about what information, how the information was gained by the sheriff's department, or whatever, I have the information that I'm going to rely on, and it's coming from Tewksbury, the letter that I got. And so if there's any problems or dust up regarding how that information was got, that may be for another day, another forum. But I'm going to be relying on that information that I got from the physician assistants, not on anything that the sheriff's department provided. Now, the reason I'm not going to deny it, I'm just not going to act on it because we still may need more information as to who the individuals are that are going to be required to be present, either in the van, or the ambulance, or here at the courthouse. I certainly think that may be something that the defendant may want to go forward on. So I'm not going to deny that motion at this time.
I also just want to make sure that in some assistance, we don't, as I understand it, require an ambulance with all of the accoutrements of an ambulance. I think basically a van with the chair, able to transport the chair is sufficient. I know that Tewksbury has done that on a number of occasions with her, bringing her to various hospitals all over the place for various testings, and they use vans. So I may have misspoken in the sense of an ambulance. I don't need an ambulance with all of the accoutrements.
Right. So I've been thinking, like I said, I've been taking into consideration the facts that I have in front of me. And so I think that's kind of addresses, what you're saying. I didn't see anything in there that required the ambulance, but I'm going to take a look at it and review that. So we've got that. Where are we in regards to the Commonwealth's evaluation of Ms. Clancy?
So now that I have the records from Tewksbury, I'll provide them to the experts. The amount of time it takes them is voluminous. It's several years worth of records, so it would probably take them 30 to 60 days to go through them. And then they would have to schedule coming here and interviewing and testing the defendant, and then prepare their reports. So we're probably looking at, for all of that to be complete, 3 to 4 months. And those are my estimates. I'm not sure. In the past, they've reviewed the records relatively quickly and efficiently, so I'm assuming they will now.
Just so
When
a
do
little
you
bit of
want
a,
dinner?
I guess warning's not the right word. This is going to trial in July. And so
I was
this is
going
kind
to
of
say,
this is
I've
not
got
even
about
good because I
20
know
minutes left
all
on
counsel
this
work very hard in this
to
case. But
finish off
we now
recording,
have
and
all
then
the
I've
records.
just got to upload
We've got
it.
the experts
But
lined
I
up.
didn't know if you
We have
wanted
trial date. One of the reasons why we moved the trial date from February to July was that we got to make sure it's going to get done. So that date's a hard date.
All right.
So that's whatever that's worth. All right. Like I said, that's not a reflection. I know that all counsel are working very hard in this case. In regards to an updated joint pretrial memo, I imagine you're going to need to have the expert's opinion, obviously, before you update that. But
1 hour
I just put that in
52.
because I know we have the trial date in
This
July.
is long.
Generally, you have a week or two before that. I think it may make sense to have an earlier final trial conference on this. Maybe some.
This is my longest video I've done, but could you just imagine it if I was doing this live and had to keep on answering questions in chat, and if I stopped more and did a lot of chit chat like some people do, how long this video would have been. This is why I'm trying not to disturb it as much as I possibly can. But I do appreciate you all watching it in your own time.
Sometime even in June.
There may be further discovery motions too, Your Honor, that we could perhaps do during March or that type of thing. So there's some other issues that would be.
Okay. I mean, does it make sense from a next date for the discovery also in regards to any reactions in regards to the transportation order? Like I said, I want to give everybody a chance to weigh in on that. So
Judge, you have a scheduling conference already set up on the 27th
of
this month.
You want to keep that date?
That's fine.
All right, why don't we keep that? I'll get this order well within that, and that'll keep me on a short leash as well. And then on that date, January 27th, that will be to review the transportation order, the trial logistics.
Yeah, this will be done in 2 parts, guys, because like I said, it's nearly 2 hours now, and it's going to take me forever and ever to download and upload it to my channel. So I'll do a part 2 either later tonight or maybe tomorrow morning now. Okay.
A little bit, maybe an idea in regards to the expert timetable. And then I don't know if that would give you enough time to figure out additional discovery. We could argue on that date.
Right.
All right. Well, just at least maybe let Commonwealth know what other kind of areas.
It would just be pretty much, as expected, different experts, other cases that they've worked on and reports of.
Just kind of, I won't say the usual, but expert related discoveries. Is that a better way to put it?
We work well together, so I'm sure that we'll be able to.
So, even if we can address it on that day, even if we're just setting dates for compliance and things like that.
Would the defendant be on Zoom for that next date?
I think so, only because it's not a final order yet. And that's kind of why I'd like to have it earlier rather than later. Then once we get the final order in place, then maybe the day after that, we can have her brought in to see if the order works. If there are any things that were overlooked by me that I have to kind of supplement or amend.
And Your Honor, defense had mentioned earlier in argument competency to stand trial. Just inquiring now, is that an actual issue? Is he going to request an evaluation?
It says it relates to physical conditions, it had nothing to do with her intelligence or ability to understand the Dusky standard, what's going on, who you are, who I am, counsel. There's no issue as to competency in that regard. I'm talking about having a person sitting through an 8-hour trial day for 3 weeks with these issues.
I mean, that's the way I took it.
Okay.
That at this point, I don't have any indication that that's an issue. We've all done during trials. The stress of the trial sometimes affects people differently, and so this would be no different than any other case if that arises. We can address it as it comes, but I don't see any indication, and I didn't take it as any type of notice that was a problem. But I think that was an appropriate question to ask in regards to that. So, anything else that we need to address at this time, Commonwealth?
Do you know at this point whether we would be going full days or half days for trial just for planning purposes?
I would probably, I'd like to say full days.
Yeah.
But again, there are physical issues that we may have to consider in regards to that. And it also may be a situation, in my experience, we might not be able to start right away, because of if she's coming down from Tewksbury. Sometimes that delays the start of a case. So why don't we say at this point, the plan would be full days, but that may change as we go forward.
Thank you.
All right.
Right, so there you go. What's been going on. So I appreciate you all watching this and staying here for 1 hour 57 minutes. Oh gosh, this was a long one. This is my longest one yet, guys. So thank you all for taking your time to watch. As I said, housekeeping rules, if you could click like, subscribe, then click all, and then that way you're notified when I do videos, or if I do lives, or if I do shorts, which I'm planning to start doing some shorts. So once again, thank you very much. And my email's down here at the bottom, truecrimefiles2026@gmail.com. So if you've got any cases you would like me to try and cover, I'm willing to try and cover most things for everybody. It just means I need to do some research in it. So thank you very much. On that one, we will see you on the next video. Goodbye.